Sorry about that. Thank you, Catherine. We are excited to present to you. We're taking you into that last hour, which is always tough, but we hopefully will make it somewhat interesting and maybe even exciting. Okay, that might be hard. But we hope that this is fun and that this will be some good reminders on what to do. We want to thank Catherine and the Governor's Commission on Volunteerism for inviting us to speak. And just to tell you a little bit about the Pro Bono Resource Center, it is a program of the Equal Access to Justice Commission, which is chaired by the Chief Justice of the North Carolina Supreme Court, Chief Justice Paul Newby. And the Resource Center has existed for 5 years. In fact, in April, we'll be celebrating our 5-year anniversary. The commission is about 12 years old, so the commission existed and was instrumental in creating the Pro Bono Resource Center. If you want to learn more about the Resource Center, please go to our website. We have a number of volunteer opportunities that we host, but also there is a clearinghouse of quite a lot of volunteer information for attorneys and paralegals. This program is important because we hope that after the CLE, you are inspired to do pro bono work and that we are all reminded of the ethical considerations when doing pro bono work. We're going to cover what pro bono is, how pro bono is the same and different as paid legal services, and we'll also talk about other issues that could affect representation in a competent way. So I will go to our next slide, which is, what is pro bono legal service? Next slide, please. The North Carolina rules define pro bono. We adopted these rules in 2010. Almost every state has some version of the 6.1 aspirational goal to do pro bono, and ours says that every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire, and so this is an aspirational goal, to render at least 50 hours of pro bono publico legal services per year. As a side note, we are in one of the happiest seasons of the year for me, which is pro bono reporting time. So North Carolina lawyers, we ask that you take a moment and voluntarily report your pro bono hours, no matter how little or how many. As I said, this rule was adopted in 2010. And according to the rule, we really do want to make sure that lawyers know how to serve, they know that this is part of their ethical obligation, and they know that we're here to help them. Next slide, please. So we're going to break down this rule a little bit, and we're going to start with 6.1a. And these are what we call Tier 1 legal services that are eligible for recognition, so sort of like what counts as pro bono. This is how we, and the North Carolina State Bar, and the rules define what is pro bono. So we'll break down the rule a little bit, and that is, we are going to start with providing a substantial majority of the hours without fee or expectation of a fee. And so you are going into this relationship without expecting a fee. And so those uncollectibles, unfortunately, don't count. Just making sure, again, that this is something that you keep in mind, because of course we want to make sure that this is truly something that you are giving, right? 6.1A1 defines who receives these services, A1, A2, and A3. And the first is legal services to persons of limited means. And these are legal services for people who cannot afford to pay for legal services. According to the comments, those who qualify for participation in programs funded by the Legal Services Corporation and other legal services providers, and those whose incomes and financial resources are slightly above the guidelines utilized by these programs, but nevertheless cannot afford counsel. So really making sure that this is not someone who could afford a lawyer, but really people who can't. And that is so important in defining pro bono. A2 is, these are organizations, and I'm going to read charitable, religious, civic, community, governmental, and educational organizations in matters that are designed primarily to address the needs of persons of limited means. So these are organizations that may be able to pay to afford legal services, but your pro bono service to them is to support the people of limited means, and those are in A1, right? And so examples here are a church or a hospital. If the legal services are in support of a program within those organizations designed to meet the needs of persons of limited means, then that counts. But if, however, you are providing services to the same organization to support the organization itself or to benefit people who are not of limited means, that service would not be under this rule. And so then we move to A3, because remember this is six, there's an or, right? And so these are organizations that are addressing the systems that affect people of limited means. That's the A1 category, right? Those are the people, or to organizations that are themselves charitable and unable to afford legal services. So if we were to look at the comments, comment 6, paragraph A3 includes the provision of certain types of legal services to those whose incomes and financial resources place them above limited means. So examples of these types of issues that may be addressed under this paragraph include First Amendment claims, Title VII claims, environmental protection claims, and additionally, a wide range of organizations may be represented, including social service, medical research, cultural, and religious groups. So a lot here. Hopefully this is digestible and easy to understand. But 6.1 has more. And that is, we move, next slide, into 6.1b. And so we want to encourage, and the preamble encourages, when I say we, I'm saying the profession, but what I really mean is the North Carolina State Bar wants to make sure that every lawyer knows, and that's part of the preamble, that is the basic responsibility of each of us to provide community service. And so that's an underpinning, right, of the rule. 6.1b talks about what we often describe as low bono, so services at a substantially reduced fee, or 6.1b2, participation in activities for improving the law, the legal system, or the legal profession. And examples of law improvement activities include serving on bar association committees, serving on boards of pro bono or legal services programs, taking part in law day activities, acting as a CLE instructor, maybe serving as a mediator, an arbitrator, and engaging also in legislative lobbying to improve the law, the legal system, or the profession. We often get questions about board service, and that's when I want to encourage you to look at the preamble, which is we definitely want lawyers to know that, that community services is appreciated and something that many people do. But board service for a non-legal nonprofit falls under community service and not the legal services that are being provided to different groups. Next slide. 6.1 also encourages us to make financial contributions to legal services to legal services organizations that provide services to persons of limited means. And so in North Carolina, the three major civil legal services providers are Legal Aid of North Carolina, Charlotte Center for Legal Advocacy, and Pisgah Legal Services in the western part of the state. And note that this is an addition, in addition, and not an either or. I'm certainly leaving out lots of other nonprofit organizations that provide legal services, but you get the gist of what I am saying. And so next, I'm going to ask one of my colleagues to talk about how is pro bono the same as paid legal service.
And before we get into that, sorry to interrupt, we do have a question. And so Sylvia, you can decide whether you want to take this or would rather Leigh or I answer. So the question is, if a religious organization has some efforts to assist people of limited means, but the organization itself is not designed primarily to address the needs of persons of limited means, does that count as pro bono legal service?
Okay. Could you read that again? I'm sorry.
Sure, and it's in the Q&A pane if you'd like to take a look at it. But if a religious organization has some efforts to assist people of limited means, but the organization itself is not designed to meet the needs of people of limited means, does that count as pro bono legal services?
I think it would. Jared, what do you think?
I think it depends. I think there would be additional facts. I think that if your services in support of the organization were supporting those areas where they were supporting people of limited means, I think those definitely would count. And if the organization itself is a religious organization which is charitable and cannot afford legal services, that would separately fall in the third category. Let's see if we can go back there very quickly. So where the payment of standard legal fees would significantly deplete the organization's resources. So it may fall in one category under 6.1A versus another. But if it is an organization that can afford an attorney and supporting the organization not specific to the areas of directed to people with limited means, that category would not fall within this rule. Hopefully that makes sense.
I just want to say that anytime someone has a question about what falls or what doesn't, we can always talk about that. And so just keep that in mind. Okay.
All right, thank you. And thank you for that question. As we're going through how is pro bono the same as paid legal service, I just want to say that we, Jared, Sylvia, Catherine, and I are always thinking and talking about pro bono. And the rules themselves can sometimes be, I think, a little bit intimidating in terms of knowing whether or not you're able to offer that service to somebody who's in need. And one of the things that we talk about a lot are we have these incredible legal service providers, people who have really dedicated their life to helping people who couldn't otherwise afford an attorney. And the resources to meet the demand are simply not there. There are about 70,000 people who apply for legal services in North Carolina each year, and about half are turned away for due to lack of resources. So as we're going through these, I just want you to know that our lens is, yes, you can do it. We're here to support you and let us know what you need to make it happen. And so now we'll start with how is it the same. Next slide, please. As you can probably guess, it's the same level of service. Rule 1.3 says that a lawyer shall act with reasonable diligence and promptness in representing a client. And of course, the same is for if you're serving that client pro bono. Comment 1 says that a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. A lawyer must also act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. So we just want to point out that there's certainly no hierarchy when you're taking on a case between that client who has paid you and that client who you are doing pro bono. And I would just note that when you're taking on a pro bono case, communication around exactly what services you're offered is really important. There's oftentimes, this will get into a little bit more of the differences, but I think it's important to point this out, that oftentimes when you are doing a pro bono case, there's just more parties to coordinate. So Catherine had a situation where a legal service provider in Alaska reached out to her, and that legal service provider had gotten a pro bono attorney to take on a matter that had to be filed within a certain amount of time, within 30 days. And it was something that could be done remotely, but as this provider was getting back in touch with the pro bono attorney to find out whether it had been done, they were having a really hard time getting in touch with the person. And finally, the person responded, you know, I've just gotten totally swamped at work. There's no way that I can take on this case. I'm sorry, can you please give it to someone else? And at that point, you know, the legal service provider was really scrambling to do that. So just to highlight that there is no hierarchy, it's the same level of service. And if that does become a problem, the provider would always rather hear from you as soon as possible. And I think this is probably something that's resonating with folks listening. They're like, yes, of course, we would all do that, but it's worth noting. I also just, if I could, I don't want to take up too much time from my co-presenters, but I think comment 4 of Rule 1.3 is also really important. It states that lawyers should carry through to conclusion all matters undertaken for a client. If a lawyer's employment is limited to a specific matter, the relationship terminates when the matter has been resolved. If a lawyer has served a client over a substantial period in a variety of matters, the client sometimes may assume that the lawyer will continue to serve on a continuing basis unless the lawyer gives notice of withdrawal. Doubt about whether a client-lawyer relationship still exists should be clarified by the lawyer, preferably in writing, so the client will not mistakenly suppose that the lawyer is looking after the client's affairs when the lawyer has ceased to do so. And we're going to talk later on about unbundling and limited legal services, but this communication piece is really important in terms of clarifying the relationship. Next slide, please. And Rule 1.1 states that a lawyer shall not handle a legal matter that the lawyer knows or should know he or she is not competent to handle without associating with a lawyer who is competent to handle the matter. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And taking on a pro bono matter is the same level of competence is required. Now, I know many of us attorneys out there are very hard on ourselves. Imposter syndrome is something that we see a lot as an impediment to doing pro bono. And so this does not mean that you can never take on a pro bono case that's outside of your area of expertise. Does anybody want to throw out in the chat some strategies to become competent if you want to take on a case outside of your normal practice area? Ooh, timely from Catherine Asaro, attend to CLE. Certainly, that's a great one. Yeah, and I know that it's, join a training with a legal service org. Yes, and this is from Charlotte Center for Legal Advocacy, who actually has a CLE training tonight. That it might be too late to join now, but CCLA has some really great trainings that they offer as part of their pro bono program. Yes. Some other ways are to find a mentor, someone who's practicing in that field to work with on a case. And These different ways spread the love, opportunity for service. Ask a seasoned attorney to walk you through the process and check your work. Yes, absolutely. And Sylvia mentioned that our website has a clearinghouse of different projects around the state, and many of these different pro bono projects and partnerships offer these types of ways to become an expert in that field of law. And I just want to note that comment 2 states that a lawyer need not necessarily have special training or prior experience to handle legal problems of a type with which the lawyer is unfamiliar. A newly admitted lawyer can be as competent as a practitioner with long experience. Some important legal skills, such as the analysis of precedent, the evaluation of evidence, and legal drafting, are required in all legal problems. So it may be educating oneself at times as well. Next slide, please. Oh, great. And the Advocacy Center has some great information in the chat as that's relevant to this. Okay, Rule 1.1 comment 3 says that in an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation or association with another lawyer would be impractical. Even in an emergency, however, assistance should be limited to that which is reasonably necessary under the circumstances, for ill-considered action under emergency conditions can jeopardize the client's interest. So this comment sort of reads like a law school exam question. If your mind is sort of spinning, what kind of emergency would that entail? And I think courts have been sort of reluctant to define exactly what that looks like. There is a Tennessee case in which an attorney is present on the scene of a motor vehicle accident where a person is about to pass away and gives kind of their last will right there on the scene. And that was the type of emergency that, even though this attorney doesn't practice and trust in estates, was competent to do that at the time. And so Catherine calls this the just being a regular human example. And yeah, we'll let our imagination sort of take it from there about what other emergencies might entail. Next slide, please. So the same level of confidentiality, this is a really important one. A lawyer shall not reveal information acquired during the professional relationship with the client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. And paragraph B states that a lawyer may reveal information protected from disclosure by paragraph A to the extent the lawyer reasonably believes necessary to comply with the rules of professional conduct, the law or court order, to prevent the commission of a crime by the client, to prevent reasonably certain death or bodily harm, to prevent, mitigate, or rectify the consequences of a client's criminal or fraudulent act in the commission of which the lawyer's services were used, to secure legal advice about the lawyer's compliance with these rules, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to comply with the rules of a lawyer's or judge's assistance program approved by the North Carolina State Bar or the North Carolina Supreme Court. All right, so here we are at our hypo. Next slide, please. Okay, so you have volunteered to spend a day in Eastern North Carolina at a FEMA appeals clinic, helping hurricane survivors navigate correspondence from FEMA. The clinic is being held at the local community college, and you are using the computers in the computer lab to do the work. Before meeting with your client, the clinic organizers give you a file with the client's name, email address, phone number, and a brief summary of their legal issue. During the clinic, you draft an appeal letter for the client, which they will then file pro se. When the client leaves, they are to take all their documents with them. Nothing stays at the clinic. You have a very productive day seeing 5 clients, and as you're packing up, you find a file on a table in the waiting area with the client's name on it. So how is Rule 1.6 implicated, if it is implicated here? And what do you think you should do. I'm going to start kind of walking through this, but I also want to give folks a second to chat. So in this hypo, the folder that you found, the documents that you found were directly distributed to the client. So that is one factor here. And maybe this is sort of, let's separate out the two questions. So do you think Rule 1.6 is implicated? And I think here the answer is yes, that there is an issue of confidentiality. There's private information that was discussed during this meeting of the pro bono attorney and the client that is now sitting on an open table at the local community college. So I think the important question here is, what do you do at this point? And here you're taking part in this appeals clinic. There is a legal service provider running the clinic. And so a good thing to do would be to alert that person and just pick up the file and give it back to the clinic. There may or may not be materials in that folder that were created as part of this clinic relationship. That's a little bit unclear from the hypo, but it's likely that there is confidential information, and so certainly not just leaving it on the table. And we have a second part to this hypo. Later that evening, you get a strange feeling that you might not have logged off of the computer you were using to draft the appeal letters at the clinic. So this is a sort of the nightmares and fears that roll around in our brains at night after doing something like this. So I guess one question would be, do you think you have a duty to do anything, having a feeling that maybe I didn't log off of that computer? And I think the answer, I don't think I know the answer would be yes. Yes, getting the thumbs up from Sylvia. That is something that you would want to report back to the person who hosted that clinic and just make sure that somebody can go and look into it. And we have used community colleges to host different types of clinics, disaster relief clinics, a driver's license restoration clinic, and oftentimes the labs that we've worked at after a certain amount of no activity would automatically log off. But it's good to just flag that, just as you would if this were a private client that you were working on their work in a public space for some reason. Okay, I'm going to turn it over to Jared.
All right, so Leigh has spent some time talking with us about how we should treat our pro bono clients the same as our paying clients. I'm not going to tell you anything different than that. However, there are some issues that come up more often in a pro bono context than might in a paid context. And there are some rules, one rule in particular that specifically applies in a narrow pro bono context that we want to cover and make sure that you're aware of. So before we get into some of those specifics, we need a little bit of a foundation here. And that foundation is the question, when am I in an attorney-client relationship? The rules of professional conduct tell us that the rules of professional conduct are not going to answer that question for us. That's your first item on the slide here, telling us that principles of substantive law external to the rules determine whether an attorney-client relationship exists. That's in brackets because the state bar uses client-lawyer relationship. However, the case law tends to refer to this as attorney-client, and that's how we'll be referring to it. Now, if you cast your minds back, for the attorneys on the call, to your professional responsibility classes in law school, and I'm sorry to make you do this, you may recall a case called CONT'D, which is the sort of seminal case that is used to teach this concept of an attorney-client relationship. And in that case, the Supreme Court of Minnesota found an attorney-client relationship when an attorney provided advice to a client or a presumed client. The client relied on that advice and was harmed by it, and then filed a claim. And the court found that because the client had received the communication and relied upon it, that there was legal advice, and that was an attorney-client relationship. And it turned on the language that may have been sort of stuck in your mind of reasonable foreseeability. It's reasonably foreseeable for a client to think that an attorney-client relationship exists here. What I'd like to share with you is that that is from a PR textbook, and that is how we might think about things. That's not necessarily specific language that we rely on in North Carolina. So let's talk about the North Carolina language specifically. We have in North Carolina had a reference to CONT'D, but specifically saying that the rendering of legal advice establishes an attorney-client relationship, and not specifically that reasonable foreseeability language. And so while we have a reference to CONT'D, maybe not the point that we're used to from that. However, we do have some different language in North Carolina that we can look to. So on the slide here, we have an attorney-client relationship forms when a client communicates, and we assume that this is a two-way communication with an attorney in confidence seeking legal advice regarding a specific claim and with an intent to form an attorney-client relationship. And this is from a Supreme Court case. We also have from 2 Court of Appeals cases some additional language here. Attorney-client relationship may be implied from the conduct of the parties and is not dependent on payment of a fee or execution of a formal contract. This is particularly important for us in the pro bono sphere, that payment is not a factor for or against a attorney-client relationship. I shouldn't say it's not a factor. A court probably would consider it a factor, but it's not a determinative one. And then finally, the relevant question for determining whether this relationship exists is whether the attorney acted in a way that a relationship could reasonably be inferred by the purported client. So we're still talking about the client's understanding, and it's still about reasonability. And here it's about inference rather than foreseeability. A similar point, probably one that doesn't change our analysis all that much, but want to make sure that we have the North Carolina language in front of you. So we know that an attorney-client relationship exists when a client can reasonably infer that one exists based on the conduct of the attorney. That doesn't mean, however, that that relationship has to exist without any limitation. And the rules give us permission to limit the scope of representation for our attorney-client relationship. We look to the Rule of Professional Conduct 1.2c for that. A lawyer may limit the scope of the representation if it's reasonable. And this reasonability is important. It would not be reasonable if the time allotted for the consultation is insufficient to yield advice upon which the client could rely. You can see here, comment 7, limitation must be reasonable under the circumstances. Comment 8, it's normally a part of a written communication that includes a fee exchange, but is not required to be in writing. Here, again, we're talking about what a client would reasonably infer from your actions. If you are telling them that you are going to give them advice in a particular matter, but you don't allocate enough time to be able to do that for them, that is not reasonable under this rule. And so therefore is not a correct and appropriate way to limit the scope. You have to be able to accomplish what you tell the client you're going to accomplish, because that's what they're going to reasonably infer from you. And this goes back to what Leigh mentioned before. Client communications are really important to help the client understand the scope around this exchange, around this attorney-client relationship. So at the end of the day, make sure that you do what you say that you're going to do. And because you get busy or run out of time is not an excuse for you to limit the scope less than that. Another point about limiting scope, a lawyer shall not assist another person in the unauthorized practice of law. And the comment here, a lawyer may counsel non-lawyers who wish to proceed pro se. And this is the key point here. is that you may limit the scope of engagement with a pro bono client to say, here's what you need to do in order to handle this matter on your own. I'm going to give you the foundation and your roadmap, and you can then do it yourself. That is an acceptable way to limit the scope. However, continuing in the comment, a lawyer may not assist a person in practicing law in violation of the rules governing professional conduct in that jurisdiction. So while you can say to a client, here's what you should do moving forward when I'm not your attorney anymore, you can't tell a client or a person that you're communicating with, here's what you should tell someone else that they should do. So an example that we like to use here is if you are in a wills conversation and you're meeting with the daughter of an aging mother, you cannot tell the daughter, here's what you should tell your mother in order for her to make her end-of-life decisions. The mother would be the client in that case, and outside of a guardianship type of arrangement. And so the client is really the mother, and that's who you should be talking to. You can't counsel someone else to be an intermediary if they are not also an attorney. In the nonprofit space, this could come up in a different way, because I think that we as public service attorneys or people who are pro bono volunteers can empathize with the idea that a nonprofit professional who works with clients in need is going to want to provide them as much as possible to address their situation. It is going to be tempting to say to a nonprofit professional who's working in a human services field, here's what you should tell your clients about the upcoming eviction crisis and what they should do, or some other situation. Here's what you should tell them that they should do. That is not an authorized practice under the law. That's encouraging someone to practice the law outside of the scope of the rules. You can say, here are resources that you can direct people to. Here's general information that may be helpful, but you cannot say, here's what you should tell someone else to do. You need to talk directly with that client rather than encouraging someone else to do so who is not permitted. So that brings us to our next hypothetical, which is about limiting scope. Here we're meeting via Zoom with Debbie, who's an executive director of a nonprofit, regarding a COVID-19 related question for that organization. And midway through the meeting, Debbie says, "You're a lawyer. I just got a speeding ticket. What should I do?" And the question presented here is, are you going to answer the executive director's question about this traffic incident? Feel free to make some notes in the chat. I'm going to go through the questions that I would ask. I definitely see some no's, and I think that that is absolutely the correct answer, and the one that we would, as a pro bono provider, encourage you to that's an impulse we would encourage you to follow. How we would think about this is, number one, who is the client that you are engaging with in this conversation? As we know, in the nonprofit context or in the organizational context in general, when we are talking about organizational matters, the organization itself is our client, not necessarily the representative of that organization that you are talking to. So number one, this consultation via Zoom is with the nonprofit organization. If you were to talk with this individual about their traffic situation, that would be two separate clients. That would be two separate attorney-client relationships. And that would fall outside of the scope established in this, presumably, in this exchange. Even if they were the same client, it is likely that for the purposes of this exchange, you had limited the scope for the client to reasonably infer that the only conversation was going to be on the COVID-related issue. So the fact that there is additional issue outside of that scope would be, by answering that question, you would be expanding the scope broader than what you initially outlined. You can do that, but that means you're no longer in the scope of the original representation, and that may have consequences, and we'll talk more about that. As a practical consideration, if you're working with a provider in this exchange, the provider has likely brought you in as their representative, as a volunteer with that organization on their malpractice policy to be within the scope established for this project. If you choose to go outside of the scope of that project, you are likely also going outside of the scope of the pro bono provider and establishing a separate exchange directly with that client, with you as attorney, them as client, unrelated to the nonprofit provider and their malpractice policy. We'll talk a little bit more about why this matters, but we come to the conclusion of no, as I'm glad to see that people in the chat have as well. Now, again, a foundational matter here, conflicts of interest. And Sylvia and Leigh, if there are questions that come up, feel free to interrupt me. Going to breeze through these conflicts. I think we generally understand if there is a conflict of interest, there are duties that we have as attorneys to avoid them. 1.7 are those for concurrent conflicts of interest for current clients. 1.9 is for former clients. So if we have one current client where there's a conflict with a former client in the same or a substantially related matter in which the interests are materially adverse to the former client. And then 1.10, while lawyers are associated, we impute conflicts across the firm unless the imputation doesn't make sense because it's purely personal. So I think we generally understand conflicts, and that's not where we're going to be spending our time today. However, it does make a difference for Rule of Professional Conduct 6.5. A lawyer who, under the auspices of a program sponsored by a nonprofit organization or court, so within the parameters of working with a provider, provides short-term limited legal services to a client, limited scope, without expectation that either the lawyer or the client that the lawyer will provide continuing representation, reasonable inference, so clear communication. If those three things are true, then the volunteer attorney is only subject to the conflicts rules to the extent that the volunteer attorney actually knows that that representation involves a conflict. So with a paying client, you might, your firm might have you go through a conflicts check process where you affirmatively look and see whether conflicts exist. Because of the nature of these types of limited scope engagements through providers, the State Bar recognizes that that is a large burden to ask people to go through, and is an impediment to volunteer legal services. So instead, we only require actual knowledge if it's within the parameters of limited scope and with a partner organization. And this, back to our prior hypothetical, matters because if you answer that question about a traffic ticket, you are expanding the scope outside of the partner organization, and therefore are expanding yourself outside the safe harbor of 6.5. And now you have an affirmative duty to look for conflicts of interest rather than relying on the safe harbor of actual knowledge. 1.7 and 1.9 are current and former, as we mentioned before. Rule 1.10 is our imputed conflicts of interest for 6.5A2. Again, you only have to actually know that another lawyer would be subject to the same conflicts. But 6.1b here, except as provided in A2, except when you actually know that a conflict exists for someone in your firm, 1.10 is inapplicable in this situation. And what that means is the State Bar also recognizes that once you go back to your firm, the volunteer experience that you just had means that you just had a pro bono client who's a former client of yours. But this rule protects you from that former client duty tracking back to your firm. So even if the interests of the pro bono client are adverse to a former or current client of someone else in your firm, that conflict requirement under 1.10 does not track back. That's only if it's an individual situation between a client of yours with another client of yours. So that's a nice additional safe harbor for moving forward. You're not asking volunteer attorneys to place out of other clients in their firm. So Rule 6.5 gives us the safe harbor if with a nonprofit and if in a limited scope context. So hypothetical 3 here. After you have provided advice to Debbie, again, in that nonprofit role about a COVID issue, and the call is wrapping up, Debbie asks if you know Oliver, who is a colleague of yours from your law firm. And Debbie mentions that she met Oliver when he represented her ex-husband in their divorce more than a decade ago. Is this a problem? I think, again, we want to think about what questions we need to ask in this situation. And I think the appropriate questions here are, what do you know and when do you know it? Because 6.5 is about actual knowledge of whether a conflict exists, whether for yourself or for someone else in your firm. So when do you actually know that a conflict exists? According to the language here, it's after you provided the advice and the call is wrapping up. When you provided those legal services, you were still squarely within that safe harbor because you did not have actual knowledge yet. Your knowledge came after the representation, after the advice, and if assuming that this exchange was within the purview of a nonprofit provider and within a limited scope program with that provider, then you are protected by that safe harbor of 6.5 until that actual knowledge arises. So based on these facts, there is not a conflict for you to worry about. You don't even have to get into what the Oliver representation was because that knowledge didn't come up during the representation. But what if it had? What if this came up during the conversation before you had finished whatever it was that you set out to talk with Debbie about? Then we have to ask ourselves, do the conflict rules apply here? Again, same as we did with our prior hypothetical, we need to ask ourselves, who are the clients here? We're still in an organizational context, so the client is the nonprofit rather than Debbie herself. So if we're looking for a conflict here, it would be between the nonprofit and the ex-husband of Debbie. Presumably, based on these facts, there is no conflict between that nonprofit organization and Debbie's ex-husband because Debbie is not your current client for the purposes of this conversation. However, there may be facts based on your conversation with Debbie that would indicate that maybe there is a conflict here and maybe I need to do something to address that. If you know that Oliver was involved in this and Oliver is in your firm, that means that conflict would be imputed. And if you have an inkling that a conflict exists, now we're talking about knowledge and now we're starting to fall outside of that 6.5 safe harbor. So for example, Ed mentioned earlier during our nonprofit overview that there are a lot of nonprofits that are small and are very led by a founding person who is very involved in the operations of the nonprofit. If Debbie was the founder of this nonprofit and it operates outside of her house, as was the situation with a client that I've worked with in the past, and you know that this nonprofit was founded about a decade ago, maybe you are starting to get some facts to indicate that maybe with 1.9, this question about, let me make sure my language is correct, about a substantially related matter in which interests were materially adverse, maybe that is starting to become implicated here. And maybe you do need to start thinking about that there is a conflict and 6.5 isn't protecting you anymore. Similarly, there may be something with the subject matter of the organization or the way that the organization is funded that might implicate some conflicts here. If you knew that during the representation, that should make you think about an actual conflict that you need to address. So practically what that means for us is we would want you, if you were a Pro Bono Resource Center volunteer in this situation, to come to us and say, I think I have a conflict here and I don't think it's appropriate for me to continue having this conversation with this client. And what we would do in that context is we would take the client back and explain the situation that we need to give them another attorney based on our ethics rules, and that we will still take care of them. They will still receive the quality advice that they would expect with their interaction with the Pro Bono Resource Center. It just won't be with you as their attorney. And so if you do need to take that step, we would help you with that as your nonprofit provider. So with that, I'm going to finish up my section and turn it back over to Leigh to talk about communications.
Yeah, thanks, Jared. We're going to talk for just a second about limited scope communications because limited scope work is so prevalent in pro bono. So if you were helping out with a small business and nonprofit project that Catherine is running right now, you would be connected to a client and given a particular question from that client, and your work would be to discuss thoroughly with that client that particular question, and then after that discussion was over, your work would be done for that time. And so, as has kind of been the theme throughout this presentation, the rules ask that we really think about this from the client's perspective so that there's no miscommunication in terms of what the expectations are and what the attorney is actually doing. So 1.4a says that a lawyer shall promptly inform the client of any decision or circumstances with respect to which the client's informed consent is required by the rules, reasonably consult with the client about the means by which the client's objectives are to be accomplished, keep the client reasonably informed about the status of the matter, promptly comply with reasonable requests for information, and consult with the client about any relevant limitations on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. And B says that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So when you are representing a client in a limited scope manner, on top of making sure that they know exactly what's going on with the case, it's really important to outline exactly what you are doing for them. And many pro bono projects and legal service providers that you work with will have built into their programs have this in writing for you. So it's something that the pro bono client will sign something saying that you are representing them for this one certain interaction or until this one goal has been met. I'll turn it over to Sylvia now.
Thanks, Leigh. So there are other additional ethical issues to consider when doing pro bono, and what we're going to talk about in the time remaining are not necessarily all the issues, but we thought these were something that issues that we thought were important to discuss. So the first is cultural competency. And we actually do a whole CLE that is an hour and a half long about cross-cultural competency. What we want to point out here is that the rules also speak to these issues. Rule 1.4, comment 1, notes that in order for there to be reasonable communication between the client and the lawyer, there needs to be, the client needs to be effectively participating in that representation. Now, if you have a situation where you might have a cross-cultural issue about a person shaking their head. Now, does the shaking of the head indicate that that person understands what you're saying and agrees with what you're saying, or are they just being polite? And that's something that you would want to ask. You would want to make sure that is this person just being polite? Is this, are there other issues affecting your communication with the client that really relate to your own understanding of what they're saying, which may not mean what they're actually trying to say to you. Comment 5 indicates that the client should have sufficient information to participate intelligently in decisions concerning the objectives, and that the guiding principle that the lawyer should fulfill reasonable client expectations for information consistent with the duty to act in the client's best interests and the client's overall requirements as to the character of representation. And so we really want to make sure that cross-cultural competency is something we believe in. We think that this is something that should be discussed more and more with attorneys that are venturing into different client populations that perhaps they're not used to. And so we want to bring that up. Next slide, please. Clients with diminished capacity, again, a whole CLE can actually be done on this, but we want to point out that the rules do refer to this, and this rule lets us know that we are going to do everything we can to treat our clients as our clients, right? Even if there is something present like a mental impairment, or some other reason that you might believe that the client is not fully understanding you, but it is your job as the attorney to make sure that you are viewing this client situation in the best way possible for the client. And I'm going to go to the next slide, which is 1.14b. And in the case where the lawyer actually believes that the client lacks capacity and is at risk of harm, an action needs to be taken, but the client won't authorize it, the lawyer may take action, which includes consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seek the appointment of a guardian ad litem or a guardian. And so here we're making sure that that those types of situations exist, but really making sure that there's harm and that the client won't authorize it. Next, and the next slide. Here is the limitation though on revealing too much, right? And so under Rule 1.16a, the lawyer shall not reveal information acquired during the professional relationship with the client unless the client gives informed consent and the disclosure is implicitly authorized in order to carry out the representation, or if the disclosure is permitted under paragraph B, and that was a list of scenarios that Leigh referred to earlier where it is permissible to reveal information protected from a confidential interaction between the lawyer and the client. So just keep this in mind. We have another hypothetical, but I think what we're going to do is skip that hypothetical and go to the next slide. And that is, we really want to make sure that you know this, that if you have ethics questions, you should know that either if your firm has an ethics counsel, that person is, you go to that person. But we also want to make sure that you know that the State Bar is there to answer questions. You might also contact your malpractice insurance provider and talk over the situation with them. There is never too many, right? Like, you know, I'm the kind of person that I love to talk about my issue with people and making sure I'm making the right decision. You may not be one of those people, but we do encourage you to ask questions if your spidey senses go up. And finally, our last slide has our information. And so please know that you can contact us with any questions. I don't know about you, but I think Jared Smith is the expert on these rules. I love listening to him because he can talk about them back and forth. And so, but please know that we're here, and including Catherine as well. The Pro Bono Resource Center is here to answer any questions you may have. So I'll turn it back over to Catherine.